Of you already logged in. Great to see you again. Jonathan, it's a real pleasure and a true honor to welcome you in our, well, I guess, virtual midst today. But as I already said, we're really hoping that we can remedy that in the future. Or Indra will come to Berkeley. These are the options that are on the table. But we'll find
all of the above.
Or we just combine that. You come to Frankfurt and then Indra goes to Berkeley, and I don't know, or we meet somewhere in the
not at the same time.
Yeah, of course not. Okay. Today it's a pleasure to welcome and say hello to Jonathan Simon, who will give a presentation. I know that I could probably introduce Jonathan for the whole 1.5 hours that we have, and Jonathan probably wouldn't need too much of an explanation or introduction, but nevertheless I'll say a few and brief words on him. So Jonathan is a professor at Berkeley. He is indeed the Lance Robbins Professor of Criminal Justice Law. He is, and that is normally said quite lightly, but in this case it's truly meant and felt one of the most preeminent thinkers of criminal law, criminal procedure, criminology, and legal studies, and sociology of law. So criminal law and society, he is really one of the preeminent scholars and thinkers in that direction. Now, he has authored countless articles, books, including the famous Governing Through Crime. And on a personal note, one could say that he's truly a fascinating person to talk to, a stimulating thinker to discuss matters of criminal law and justice and sociology with. And this, of course, would alone justify the invitation. But in our case, it's also warranted with regard to the actual topic of our lecture series. As Jonathan is one of the founders of a, let's call it, well, then it was new, a new and radical way of diagnosing criminal law and justice, its administration, something that is called the new penology, or also actuarial justice. So how crime or criminals or groups are actually controlled by technology and statistical calculations, and that help us, in inverted commas, to identify and manage high-risk, dangerous, or unruly individual or groups. So what he did long before we actually knew what algorithms are, he already identified that these actuarial models and technocratic tools are employed to manage these kinds of risk, inverted commas, of course, risky groups and individuals. And in his rather new work of the last years, he now links them to remnants of darker thoughts and concepts like Eugenics. And this is, of course, then also why that will explain the title of his presentation today, which is called From Eugenics to Big Data, a Genealogy of Criminal Risk Assessment in American Law and Policy. And it's a real pleasure and honor to have you, and we're really looking forward to this, to your presentation. Jonathan, you have the floor, and of course you have the possibility to share your screen.
I'm going to try, and there's an advanced mode, and just let me know if this works. If it doesn't, I'll go back to the more standard approach, but let me see if it will do this. Can you see me? Can you see the slides as well?
Yeah, that looks fancy.
That looks nice.
It only works in, I guess, if you have a high enough res.
Yeah.
At any rate, I'm very grateful for the invitation to reflect on what has been a long-term interest of mine. And when one does that, one is inevitably bound to think about your own previous ideas about that idea. And so you're going to get a little bit of a reflexive presentation here. One thing that we share, I think, across these national legal cultures at the moment is a great interest in algorithms and the way in which they are coming to operate within the structures of legality, and especially the criminal legal system in the US, as we'll turn to. Here, of course, we're also going through another thing that may not be so prescient in Germany and Europe, which is a reckoning about racism and especially its role in, or its integration with our criminal legal system. And so I could have given an alternative title. Might have been something like how criminal risk assessment became anti-Black, because the history of anti-Blackness, I think, is deeply woven into the history of formal modeling of criminal risk and efforts to sort of accelerate the criminal legal system's ability to sort of operate on that. So indeed, we are going through, and can you now see my slide that says the new penology on it? Good, because sometimes they freeze up and students are so detached sometimes in this pandemic era that it'll be like 20 slides later that somebody will private chat me out. It hasn't moved in about 20 minutes, Professor. Well, thank you. So wave vigorously if I seem to go way off the slide. As Christoph was kind enough to mention, an article with my mentor and colleague, Malcolm Feely, in 1992, sort of made what then seemed like a somewhat audacious prediction or claim that the US criminal legal system was coming under a sort of new regime of risk-oriented penology, what we call the new penology. And indeed, right now in the US, if you were to come here, or if you pay attention to debates about reform in the criminal legal system, we're indeed in the era of the new penology. Something like 25 states have formal risk assessment tools as part of their sentencing process, although not all, it's rarely mandatory or controlling necessarily. What we call bail, or the method of releasing people from a pretrial detention, is undergoing revolutionary reform in the US, but a lot of that reform is oriented around using formal algorithmic or actuarial tools to predict the risk of criminal offense by pretrial detainees. So, we seem to have done a pretty good job, and maybe it's time to pat the back and retire. Indeed, in social science, if you're a few decades off, that doesn't seem too bad. I'm reminded of the scientists in Terry Gilliam's 12 Monkeys, who kind of keep trying to send the person back to the right place in history to affect it, but they're off a little bit. It's hard to predict history, especially before it's happened. But I'd rather not take that self-comforting approach, because I think in talking about a new penology, which by the way was hilariously misnamed in the sense that what we actually called the old penology, which was this sort of effort to individualize and know the truth about individuals in all of their holistic complexity, what was once called the new penology in the 1890s. So it was a poor choice of a term. Actuarial justice was better. But more importantly, it hinted at a kind of historical genealogy that was, in my view now, way overly simplistic, that saw basically a kind of penology oriented around individual knowledge and assessment of the individual as a kind of holistic entity, as a kind of dominant theme in American penology throughout the 20th century, a kind of successor to the classical liberal concerns with deterrence and retribution, but like them, focused on the individual as the center of penal justice. And now we were in a new penology in which suddenly the individual, whether as a retributive or deterrent subject or a rehabilitative subject, was being de-emphasized in favor of a sort of focus on the risk level of different sort of statistically defined groups. But that genealogy turned out to be, I think, way too simplistic. By the way, there were a lot of other people pointing to the same trend at the same time, earlier than us, in fact. So it's a bit of luck, and I'd be happy to talk about some of the intellectual history of why this article ended up being sort of identified with this claim. But if you can see my table now, I'm going to linger on this for a while, so it may freeze. If it appears to freeze, it's just because I'm not going to shift for a bit. My PhD advisor told me that there were two kinds of sociologists. There were people who made lists and people who made tables. I always identified with the table side, although it's really just a way of organizing a list, I suppose. It at least gives the appearance of rigor and produces a certain amount of transparency. So I want to use this to kind of suggest that we need to actually hop around a bit in our history, our genealogy, to use the more Foucauldian description, or the Nietzschean, since I'm in Germany at the moment, approach to thinking about history as not necessarily the continuous unfolding of some essential world spirit or truth, but a much more contingent set of developments. And so I'm going to start at the present at the top, and then revisit the era in which the new penology was written, but then suggest that that we have to go back farther in time to make sense of the kind of American obsession with criminal risk assessment as a formal model, which is not the fullness of algorithms in their contemporary form, but is already an early kind of commitment to that direction, I think. So yes, today we look around, and whether you call them algorithmic or actuarial, I'll come back to how much difference there might be between those terms. Criminal risk assessment is very, very popular in policing. PredPol, which is my exemplary form of risk assessment, is an online available, essentially private sector toolkit for police departments to predict where crime and when crime will happen, and to distribute their officers. But I could have put up any number of sentencing or bail-based models. I think in understanding the success of these popularity of this approach, this algorithmic justice model today, unlike actually when Malcolm and I wrote the new penology, we have two things going on that I think are important in my understanding of why this is now successful when actually it wasn't terribly successful in the 1990s. And that is a kind of permanence of austerity logic to governance, especially at the state and local level in American political life, and the state and local level is where the penal state lives for the most part in the American polity. This is, I think, a long-term feature of German political life, concern about fiscal austerity. In the U.S., it comes and goes, since at least the early the crisis of the financial system in 2007, 2008. The problem of spending money on crime control has become far more visible as a problem, and seemingly permanently so, than it was in the 1990s. Secondly, and to use an overused term that I guess we could trace back to another German thinker, Jürgen Habermas, the penal state in the US is in a fairly described legitimacy crisis of a sort that it was not in the 1990s, with especially a focus on its racism. And by that, I mean its systemic or structural racial focus rather than the particular attitudes of the people who make it up. This seeming revolution, and I think may indeed be a revolution, unlike the last time we predicted it, is also fueled by, I think, epistemic conditions of possibility. We have what I would actually dub sort of computer revolution part 3, the proliferation of super powerful processors, as well as the emergence of tools to sort of make all data assimilable to a common framework of analysis through scraping and other techniques that take advantage of the World Wide Web, as well as of programming successes, the so-called, whether we call it big data or AI, and increasingly the two are fused in many ways. This is coming to us in all directions. and it's the criminal legal system is not the first place to be revolutionized by it. It has never, because it's part of the public sector, been at the forefront of the uses of new technologies, but it is now fueled in part by the fiscal crisis and the legitimacy crisis, turning to these tools to try to reduce costs, control the overgrowth of incarceration, answer the claim that there's too much aggressive policing. And this is exemplified in something like PredPol, which police departments have been signing up for at high numbers since the fiscal crisis. And we sometimes act as if the penal state in America sort of only grows and only gets fed and nourished by the state with revenues. But in fact, police departments are singularly vulnerable because they're dependent on city or county resources, which are the least robust and source of revenue in American fiscal policy. So they've been maybe even more advanced in trying to spread police officers, maybe a fewer number of officers across a city. They're using these predictive tools that have real-time so-called machine learning capacity. And what they do is basically create rectangles on a map of the city, red rectangles that are about a football field or a soccer field or two in length, and predict that at 3 p.m. There'll be several assaults and robberies, say, in this rectangle. And the basic idea is that police are then to concentrate on that area. We can come back to this. It sounds appealing on that level. The problem is that they also can predict with much more efficacy minor criminality, like drug sales, drug use, vandalism, and other kinds of disorderly or low-level criminal conduct. And of course, once police go to an area, saturate an area, it's much more likely that they're going to come upon that kind of activity than they're going to see that actual assault or actual burglary happening. Although they may deter those serious crimes, they're actually not reducing the number of arrests typically that they're doing. So here we are in the new age of the new penology. Let's jump into our time machine for a moment and go back to the early 90s when we wrote the new penology. And I think now we can say that we were in the midst of a period that had begun sort of in the early 1980s when mass imprisonment was already becoming visible and the growth of policing had already unfolded for a decade or so in the US. The RAND Corporation Selective Incapacitation Study, published in 1982 and cited in the new penology as sort of exhibit A for what the new penology looked like, a kind of classic social science-oriented multiple regression analysis of a bunch of data about actually California prisoners who had been asked to self-report on criminal activity. It then identified 8 factors that could predict sort of who belonged in the highest level of risk of committing future burglaries and robberies with supposedly a high level of efficiency. Now, RAND, being a properly sophisticated research organization, eventually dismantled its own claims about this in a series of studies that showed that the California prison population was probably not a good pool for predicting what this would work like in the real world, since they were already over-concentrating people with property crimes at the time. But in any event, it looked to us at like the future or the soon-to-be future. This notion of actuarial, it sort of exemplified the shift that we were identifying ourselves and that was then much being discussed from a focus on criminal risk assessment, which had already been part of American justice for about 3/4 of a century at that point, but a shift from what was essentially a clinical model where somebody like a parole board member or a judge would look at a holistic file that included not only the criminal record of a person, but also their school records, interviews with their family, a sort of social diagnosis, one might say, borrowing from an earlier era. And that was being definitively, it seemed, rejected in favor of this purely actuarial approach. when we look at the sort of problems that are helpful in understanding why this seemed like an appealing approach in the early 90s and the late 80s. First of all, we were in the midst of what we now know would be a historically epic growth in our prison population. And indeed, the people who wrote the RAND selective incapacitation study were very much trying to catch the attention of California's correctional managers and convince them that mass imprisonment might not be necessary if they could pick the right people to imprison. That effort failed, and we ended up going toward mass imprisonment anyway. But that was part of the logic. Our article talked about the emerging correctional logic because we thought that would be the place that this would catch on. But as I've already suggested, it was also gaining force from a widespread critique of clinical prediction. And interestingly, this was in the criminal legal system. Again, to go back to the history of racism and concerns about the criminal legal system, the early 1970s, late 1960s was a period when many people who were pursuing racial justice and civil rights began to suspect that clinical risk prediction by judges and parole boards could be used against Black people to view them as more criminally inclined. And indeed, that was certainly the case, pretty much baked into the system, as we'll see in a moment, but also in the psychiatric system, where America had a very large psychiatric custodial population in the 60s and 70s. And this was coming under scrutiny as being abusive, even totalitarian, and the claim that psychologists could predict who might be dangerous was coming under severe criticism. There were studies that suggested that psychologists were no better than flipping coins at predicting who might become violent or dangerous. This revolution was also being driven by epistemic developments. We essentially had the computer revolution part 2, which was essentially the birth of the so-called microcomputer at the time, the desktop computer. Prior to the early 1980s, virtually no state or local criminal legal system in the US had essentially a full computer system of their own. They might be relying on the state's mainframe computers to run their biggest reports and things of that nature, but there was no easy access. It was virtually a paper system still when I was doing my studies of parole in California in the 1980s. And then with the birth of the desktop computer, suddenly the ability to do a quantitative analysis was on the desktop of everybody. Thank God it came in time for my dissertation. Otherwise, I don't think I would have succeeded. So this really did enable at least the potential for a sort of technocratic revolution. Again, we were overly, I wouldn't say optimistic because we didn't necessarily think it was a good thing, but overly confident in predicting that this was going to catch on. Another, and I think equally important sort of epistemic shift could be described as sort of the growth of law and economics in American academic life, and especially around the legal system. This is part of the larger neoliberal revolution in policy thinking and legal thinking in the US. But at the heart of law and economics was cost-benefit analysis, or at least a lot of what it was pushing on the administrative state at the time was quantifying, using data, and essentially formally identifying objectives, which is another way of saying modeling things, creating formal models, and then running numbers. And indeed, in talking about actuarial justice, we're very much looking backwards in a sense at the revolution in insurance and indeed in the administration of the social welfare state that had given rise to essentially table-based governance in both the private and public sector in the late 19th throughout the early 20th century. And so Malcolm and I, if you read the article, kind of thought this was sort of a delayed revolution that had already transformed much of civil justice and was now coming to criminal justice. Here we were influenced directly by Foucault, who had been at Berkeley, and where I had been introduced to François Evald's work on l'État-providence and the growth of the insurance logic in European governments, which was less visible to us at the US at the time. In addition to RAND, we had one thing thing that looked like a real sort of movement in the legal field toward actuarial justice, and that was the federal sentencing guidelines, now infamous, highly formalized sentencing system. Problem is, actually, we can talk about this more, the federal sentencing guidelines didn't adopt an explicit risk model at all, because for a variety of reasons, they thought it would either be ideologically questionable to focus on future dangerousness rather than past guilt, or because they thought it would be too expensive to actually get the data on risk. They ended up relying completely on both the seriousness of the crime, but also on criminal record. And that was where they basically packed in the risk assessment. They viewed criminal history as the best predictor of future dangerousness. And this was no accident. It, as I'll come to in a moment, was very much anchored, baked in, you might say, by the eugenic era, the birth era of American criminal risk assessment, when the born criminal, the persistent criminal, became the icon or defining paradigm of criminal risk. Identifying the born criminal, the natural criminal, became the focus of risk prediction in the field, and essentially making criminal record a major vector of risk assessment has been the most consistent pattern in American criminal legal use of essentially formal models, in a sense, since the 19-teens and 20s. Moving a little bit more quickly now, because I want to, I promised I would try to speak for less than about 45 minutes. What we ignored, we sort of understood that the new penology in the 80s and 90s was breaking off from what we thought of as a continuous sort of focus on individualization and clinical risk assessment, with some rare exceptions or rare early indicators of a future like the new penology, since the beginning of the 20th century, that had suddenly ruptured and produced this new penology. In fact, now I think it's clear that we really need to think of a sort of two sort of transformative moments that underlie this. The first is what was once described as the progressive era in the US, when a variety of reforms of the legal system, some of which are borrowed from the continental models, including Bismarckian Germany, with things like workers' compensation and other social insurance mechanisms. This was very popular in the US during this period. There was an effort to really ameliorate some of the damage done by capitalist industrialization. But in the criminal legal system, the focus of this period is best known for its interest in essentially clinical risk assessment. This is the era when both parole and probation, juvenile justice, to name a third criminal legal institution, are created with the idea that they could produce a sort of expert-based identification of the criminal risk of a person, also perhaps identify ways of reforming them. This was also, however, the beginning of the era of using statistics to try to predict what was beginning to be thought of as recidivism. People who had already been to jail or prison once, but came back again with a new criminal offense, raised the question of, can we predict who these people are? This was also the era where the criminal problem was coming to be identified more and more in American cities, essentially with immigrants who were flowing to the United States from Southern and Eastern Europe following the Civil War in the 1870s and 1880s. Much of the recidivism, the repeated crime that American criminal law experts claimed was growing, was blamed on immigrants. That turned out to be false in terms of actual social science research. But organized crime, which was emerging in American cities or being identified, was identified very much with immigrants, as was anarchism, which was the term applied to essentially political violent activity in the early 20th century. So these were some of the sort of social political problems that defined a need to move from retributive or deterrent justice, or even efforts to reform everybody with hard work or other methods, toward trying to identify the dangerous few. And this is the birth of what I call the myth of the dangerous few. And the real power behind this epistemically was the enormous success of eugenics in American public policy and academic life. The only European countries to come close to the US in this regard are really Germany and Italy in their fascist periods, and they were somewhat behind the US and somewhat borrowing from the US in this. Although eugenics was born effectively in England with Francis Galton's work, this idea that we could socially engineer out problems like crime and poverty and mental illness by controlling reproduction as well as immigration really caught on in the US, partly because of the incredible levels of immigration, which were then, as now, fueling nativist, racialist anxiety on the part of the white settler community. This was also the heyday of criminal anthropology in the United States. The work of Cesare Lombroso had far more popularity in the US than it did in Europe, and it was embraced wholly by American legal academics who saw it as simply another tool in their toolkit. I could go on, as Christoph knows, endlessly about eugenics. It's the real driving force behind the transformation of the criminal legal system in the early 20th century in the US. Not only does it directly promote these new institutions like parole, probation, and juvenile justice, but it's also behind the biggest wave of criminalization in our history, prohibition, the criminalization of alcohol production and consumption and distribution, which actually takes a constitutional amendment, which we've rarely done, but we do. And it's largely seen as a tool to protect the white race from miscegenation, from racial mixing, as well as degeneration through they believed in sort of Lamarckian biology at the time. There was already in this period the beginnings of a kind of actuarial approach, and as Bernard Harcourt shows even at greater length in his book Against Prediction, the University of Chicago sociologist Ernest Burgess, part of the Chicago School and best known for their studies of neighborhood-based theories of crime causation, but he was also a pioneer in the use of statistics to try to predict recidivism. He worked with the Illinois prison system and analyzed waves of Illinois prisoners that had been released. He combined demographic statistics, a focus on race and nationality, with sociological categories like the ne'er-do-well or the alcoholic, to try to identify the pattern of formal indicators that would best predict recidivism. Interestingly, Burgess found that race was not a predictor and did not see it as a valuable way to predict future recidivism. But the larger belief that was anchored, I think, permanently in our criminal legal system during this period, and which Burgess didn't disagree with, but didn't actually identify independent data for, was that Black Americans represented a singularly, from a eugenic point of view, criminalized population. They were also, they were grouped in along with Jews, Italians, Slavs, and other sort of not white enough European populations as highly criminal, but always seen by the American criminological community and the criminal law community as the deepest level of criminal risk. And we'll come to that in a moment because it's partly a local story. You have to understand American cities to understand American criminal legal developments. So the other period I wanted to highlight in my genealogy is sort of what we had previously thought of as just kind of in the middle of the old penology. And this is the period where there's really a debate between clinical and actuarial forms of predicting criminal risk. This is the era when it's the era I write about in Governing Through Crime, when issues like juvenile delinquency and urban crime were driving forces. And the real goal of the sort of risk assessment mobilization in this period was to try to get ahead of that crime wave by trying to predict who were the most persistent offenders with at least some aspiration to reforming people, but more a focus on incapacitation. And I'm blocking it, but this is Computer Revolution Part 1. There it is. It's the era of the mainframe computer. My father, who was a sociologist in the 50s, was part of the last generation to actually do hand sorting of data to try to calculate frequencies and then even do regression analysis. By the early 60s, even sociologists could get on mainframe computers. They were becoming common enough. And the big research in this period I'm going to come to in a moment, and I'm blocking with my body at this point, I won't try to move, is Marvin Wolfgang's influential study, Delinquency in a Birth Cohort, which is really building on statistical studies of juvenile delinquents that are growing rapidly in the 1950s and 1960s. So here are some of the people I've been talking about. Burgess, another important early actuarial sociologist, Sheldon Gluck. Gluck and Burgess were sort of the competing models in the mid-century. There's Marvin Wolfgang. Peter Greenwood was the major author of the RAND study of selective incapacitation. So let's take a trip back in time to Philadelphia in essentially the eugenic era, when I want to argue that America's obsession with criminal risk assessment and with anti-Blackness sort of came together. The research of historian Khalil Muhammad in his book, The Condemnation of Blackness, is central to this argument. And as he points out, Philadelphia in the early 20th century was, along with Chicago, one of the most important Black criminality research sites in the nation. And what's really interesting is that today, of course, we understand our criminal legal system as deeply obsessed with anti-Blackness. Fascinatingly, outside of the South, in the 19th century, even at the very beginning of the 20th century, the criminal legal system in big cities in the North, in the Midwest, in the West, were not obsessed with Black people, primarily because there were very few Black people in those cities. Up to the World War I, over 95% of all Black Americans lived in the South, most of them in deep rural hamlets. They were essentially a peasantry, like the European peasantry, but even more oppressed under a segregated legal system. So it wasn't until World War I, what we call the Great Migration, that Black people became immigrants in America to the same cities where immigrants had already been the main focus of criminal legal attention and the main reason for adopting police and building prisons. But Philadelphia would be a beacon, and it would be a beacon because it was the one city in the North that did have a large Black population dating back to the American Revolution. It's no accident that the great W.E.B. Du Bois, really the inventor of empirical sociology in America and the first Black person to earn a PhD from Harvard University, when he writes that dissertation. By the way, he comes to Germany and studies with Max Weber. It's a fascinating side story that I won't go on right now. He's really the giant figure in American sociology of the 20th century. But he does his dissertation on Philadelphia, largely because it's the only big city in America that has a large Black population. And because as an emergent sociologist, he understands that to be a modern person, you have to be an urban person. And he wants to show that Black people are modern people and that they have all the same problems and prospects as other modern urban dwellers. But of course, in doing that, he highlights and then statistically produces one of the first statistical studies of criminality in the Black community. And he unwittingly, and then he'll spend a lot of the rest of his career fighting these stereotypes and myths, helps to build the picture of criminality in Philadelphia's Black community as a central public policy problem. And indeed, as I've been suggesting, up until this point, Black elites, the few of them there are in American cities, feel ignored by the American criminal legal system. They're trying to get the attention of prosecutors and judges and police commanders who are much more concerned about European immigrants and labor organizers. And part of that is to start talking about how dangerous crime is in Black neighborhoods. So in some ways, the debate we've been having about whether Black communities are served by less policing or more policing really began in this era in an effort to put Black citizens on the map at a time when they counted essentially politically for nothing. Nonetheless, at Philadelphia, as the kind of core American city, to have a large Black population and to have that Black population's criminality sort of highlighted and publicized and social scientifically validated really becomes a kind of center of a long-term pattern of anti-Black criminalization. The Philadelphia police at mid-century and the legal system become what remains one of the most racist criminal legal systems in the country. I'll talk in a moment about the era of the 1960s where Mayor Frank Rizzo rises from police chief to mayor and becomes sort of the epitome of the governing through crime anti-Black politician in America in the 1960s and 70s. But this is also the site, and this becomes kind of a feedback loop between sort of political history and then social science history. It's the site where Wolfgang and his colleagues, including the great Thorsten Sellen at the end of his career, conduct this pioneering study of delinquency in a birth cohort. And I need to spend a moment on this to highlight its epistemic break qualities. Up till then, most statistical studies of recidivism or criminal patterns started off with a population of people in prison being released. And I think you can all appreciate the problem of that from a social science point of view. This is not a random assortment of people. You're essentially taking a very selected, filtered population that has perhaps indeed been selected on what we would call the dependent variable, their criminal repetitiveness, and you're then using them as a baseline to try to identify patterns. What they did instead was look at an entire birth cohort, and no random birth cohort. This is 1945, the baby boomers. So these are the folks that will become the sort of first focus of the American crime wave of the 1960s, and already of great interest to social scientists who are doing this work in the 1960s. And what they do is using school records and birth records. They essentially initially look at boys only, and then at girls in a later study. They essentially look at every person born, but then most of their study, looks at those that are arrested once and then their future arrest pattern. Now, they never acknowledge that using arrest rather than self-report data obviously introduced another huge filter. Who was the Philadelphia police concentrating on in arresting? Well, we know that from the history that unfolds after the 19-teens. Once immigrants fade away as a source of moral panic, we have an immigration restriction law in 1924 that essentially ends all immigration from Southern and Eastern Europe. It's an explicitly racist eugenic law that ties your ability to migrate to the United States to the essentially percentage of the US population that your people of your nationality made up in the pre-immigration period. So you had to be from Northern Europe, basically, to come in. Once that happens, the Philadelphia police move from ignoring the Black community and basically containing or even encouraging criminalization, criminal organized crime and vice to locate in the Black community. Beginning in the 20s and over the next 50 years, the Philadelphia police will concentrate on arresting Black Philadelphians. And so when Wolfgang goes into, and his colleagues study the birth cohort from 1945, they're analyzing a birth cohort that has then been greatly reduced by the police focus on young Black boys and men in Philadelphia. This era has only ended, if it has ended now. Rizzo versus Good, which is the name of a US Supreme Court decision on blocking, is 1976. That itself is a signal of some importance. The Justice Department, which is part of the federal government in 1975, sees the Philadelphia police as so racist, so violent that they actually sue them, which was pretty unprecedented at the time. The US Supreme Court throws out the suit on the grounds that essentially the federal government doesn't have jurisdiction to try to intervene in a city's management of its police force. Less than a decade later, and another sign of just how hardcore racist the Philadelphia Police Department is. Notwithstanding having a black mayor at the time, the police department drops a bomb on a house occupied by a black militant organization called MOVE, leading to a fire that incinerates 11 people in the MOVE house, including 5 children, and burns down an entire neighborhood, a black neighborhood in Philadelphia. It's only today, if you're interested in the movie, in seeing a movie about it, or a documentary, Philly DA, about Larry Krasner, who is the new reform DA of Philadelphia, and is trying very self-consciously to break this pattern. But here's a few quotes, just get a sense of this. So the Condemnation of Blackness is Khalil Muhammad's book about the sort of focusing of criminal justice on black people in America that happens in the eugenic era and is partly a product of criminologists and social welfare agencies sort of trying to show that immigrants are rehabilitatable, but black people aren't. They're the real source of crime. That's why it calls it the Condemnation of Blackness. But here we have this 1972 published study that has had a huge influence on American criminal legal thinking, and is by no means seen as racially insensitive. Indeed, Wolfgang was a racial liberal whose research supported some of the fight against the death penalty in this period. But here are just some quotes from the study that give you a flavor of it, explaining why they developed a highly sophisticated actuarial scoring system for the level of criminal harm done. Why do it? It yields more meaningful results. For instance, in the study of recidivism in offenders of different racial and social groups. So the goal here epistemologically is to come up with more efficient ways of racially profiling crime. His conclusions from the study as a whole, from ages 9 through 30, non-whites account for nearly 80% of all offenses involving physical injury to victims. They're the most dangerous criminals. And this is, again, a pillar of liberal criminology. For each chronic offender incarcerated for a year in the 14 to 17 year age span, 4 to 5 index offenses would be prevented. A strong case for incapacitation using actuarial means. And then in their later study of the 1958 cohort, that's pretty much my birth year, I'm 59, they're more violent than their, quote, urban brothers born in 1945. And I don't think that Wolfgang was using brothers in a directly racially signaling way, but having already concluded that Black Philadelphia youth were the center of violence in Philadelphia in 45, to describe their 1958 big brothers as even more violent and dangerous was surely a prescription for mass incarceration. I'm almost done. I won't spend much time on the slide. I think it's a good question whether there's really much difference between actuarial and algorithmic versions of this. If there is, I think it lies in some of the things pointed to in the yellow rectangle. While actuarial systems classically are tied to one institution's own data, say the Illinois prison system or the Chicago Police Department, modern big data modeling can use multiple systems. Data hacking is just a colloquial phrase for finding techniques to bring data from the public health system and from Google and from the welfare system and from the criminal legal system into one analyzable data set. Therefore, it's more multidimensional. It's also possible that you can turn around and use it to analyze discrimination in the system. So there are some qualities to it that are there that may not be available in a classic actuarial system. And here's an excellent analysis of that by Kelly Hannah Moffitt that I would recommend, and she's probably written more since. So let me just close by highlighting some of the concerns that have been raised about risk-based penologies, whether we call them actuarial or algorithmic, since we wrote in '92, and especially since Bernard Harcourt, who you're going to be hearing from later this month in his important 2007 book, Against Prediction. First of all, the racial bias of risk prediction is probably the biggest issue in the debate today, which is really interesting. It hasn't been the center of the debate in the past. Essentially, it's a debate among people who think that actuarial or algorithmic formalized risk prediction using data will be at least less biased than other forms of decision making, or that it can be corrected for by some statistical means. I'm fairly persuaded by, I think, some of the most sophisticated thinkers about the sort of modern statistical science and data science elements of this, who apply it to law, somebody like legal scholar Sandra Mason in the United States, who basically argue that race is inextricably baked into criminal risk assessment in America. And they rather than basing it on the sort of specific genealogy of Philadelphia I just gave you, they base it on, two arguments that I think are consistent with that genealogy, although more general. One is that, consistent with what I told you about the Philadelphia police, we know that policing has focused on Black people for a half a century or a century. Therefore, the criminal records that we're going to use to predict risk in almost all of these systems are already oversampling Black people and are going to be biased against them. But at the same time, and again, you can see the roots of this in Philadelphia, the efforts to both push organized crime and vice into Black communities to provide them little in the way of internal police protection that began with the Great Migration after World War I, also means that at least the kinds of crime that we define as state interest, property crime, drug crimes, violent crimes, are deeply overrepresented in segregated Black neighborhoods, as they have been since Du Bois's time. And so whether because of oversampling or the social construction of essentially the Black segregated neighborhood as a hyper criminogenic environment, if one wants to predict crime, what is going to have race baked into that prediction system? Now, they argue that Sandra Mason and her colleague Megan Stevenson have argued in an interesting paper that we ought to use the same tools to really turn around and instead of focusing on the individuals and trying to incapacitate them, instead focus on the neighborhoods and try to resource them with what we think of as crime preventive methods. And that's very normatively attractive. We can talk about whether that's a feature that we can go on. Another problem, of course, is what have been called zombie predictions. I had to get zombie in here since I knew Christoph would use the term zombie earlier. It shows I can predict the future even in the very short term. But the problem here is rather clear when you think about the fact that, say, the homicide rate in New York City went from about 2,000 homicides in 1992 to less than 500 a year by the mid-aughties, right? So the same city had a radically different level of violent crime. So if you're basing your predictions on data collected in New York in 1992 and you're using it to sort people in 2007, there's a problem there. And it points to the real problem with this whole approach is the focus on the dangerous few rather than on the dangerous conditions. We're locking in a high baseline of fear. All of these systems essentially overestimate risk or identify high risk as a category with essentially rather numerically low levels of predictive risk. And finally, that at a time when we're having a serious legitimacy debate about the criminal legal system, and this would probably be why it's popular among correctional and police systems, algorithmic risk assessment is giving a scientific imprimatur to a system whose origins lie not in scientific evidence, but in myths and racialized constructions of an earlier era. And with that, I'm going to stop sharing and come back to being just another little cell in the grid here. That was a lot longer than I hoped. Sorry about that.
Dear Jonathan, if I may, thanks so much. It was super impressive. And although I'm not from the criminal law department, I learned a lot because it's something that we can transfer easily, I think, into any type of risk assessment, whether it be health law or data protection or whatever. So thank you very much. And I also like the idea of creating people who are doing lists and also people doing tables. So I'll check whether that is a valid assessment for human beings.